All right, good morning, everyone. It's 10:01, so I'd like to call to order the Judiciary Committee meeting for March 31st, 2025. This will actually be our last public hearing of the session, so glad everybody with us. We have a relatively abbreviated list today, which is good. So we'll try to get through it and get folks out of here at a reasonable time. All right, first up will be Brian Marzik.
Good morning, Mr. Chairman. Yep, I'm here, Brian Messick. I'm also here with Suzanne Corbett, number 12. If
Okay.
it's all right, we'll testify together, and I promise we'll be brief.
Absolutely.
Brian Messick for the State Marshal Association and Suzanne Corbett with the Litchfield County State Marshals. We're here to make just a couple brief comments on 7255, the Court Operations Bill. Our group filed written testimony on that as to sections 15 and 29. Just briefly, Section 29 appears to concern prejudgment remedy writs of attachment, and it looks like there might be some drafting and timeline issues there. So we filed testimony on that. Any process, we would need to have a reasonable timeline for marshals to make service in proper order. And then as to sections 15, those are the venue changes concerning the Litchfield County Courthouse, the towns of Avon, Burlington, Canton, Farmington, Granbury, and Simsbury. And Marshal Corbett will make a couple comments on TROs and the Litchfield County Marshals.
Good morning. My name is Suzanne Corbett, State Marshal, Litchfield County. Thank you for the opportunity to speak on behalf of the State Marshals regarding HB 725. Two main concerns that we have in Litchfield County with the additional courthouses coming into the courthouse, mainly with restraining orders. Each time that we are on duty and called to the courthouse to meet up with applicants on restraining orders, we meet with them at the courthouses. My concern is that if they need to be transferred into Hartford County, that would mean meeting with these applicants, getting the restraining order to them, and somehow getting them to the state marshals on duty in Hartford County. I do believe that would be a delay for the applicants and an unnecessary one. Also, fair compensation for the travel for state marshals in the county. We have one of the biggest counties in the state. And each time we go to the courthouse, of course, we are on duty, but I do believe that there should be some kind of compensation put in regarding, especially if we are not able to serve the restraining order, but have to pass it on to another marshal. One thought might be that the courthouse, the clerks at the courthouse might be good if they become more of an active participant in helping these applicants, meaning the transfer of the TROs. Example, when people have gone to the courthouse in Litchfield, and let's say the restraining order is for someone in Waterbury. There's times where I've met with these people and they don't understand the reason why I can't serve it. They might want to serve that day. They don't understand that we
We'll answer any questions.
Yeah, we have plenty of questions for you, I think. Representative Fishman. Or sorry, Senator Kissel first, followed by Representative Fishman.
Thank you, Chairman Staffstrom. I just had I know that I've spoken with Judge Bizzuto because they have space up in Torrington area, Litchfield area, and they seem like they have a lack of space here in Hartford. And I've spoken with Rep. Osborne. She had some issue being a practitioner in that Simsbury Avon area. But have you had a chance to just sit down with the judicial branch and talk about some of these concerns, either one of you?
We did get advance notice in December of some of these changes. We expressed some of our concerns, but there probably needs to be a little bit more conversation about it. Our concern is just the applicants in the affected towns to make sure the expedient transfer happens. They cover a really large geography over there, and adding these towns on the outside, we have no objection to adding them to the Litchfield Judicial District. We just want to make sure that TROs get served expediently in those areas. And for example, if they're required to report at 4:30 to the courthouse in Torrington and it's for service in Farmington, I mean, there could be a delay. They're also required to travel across their county. So sort of, as I know the committee is also working on another proposal concerning electronic transmission to us, I think we could probably pair those two things together, but we would need the branch to participate on that as well.
Yeah, and I can't speak for the chairs of the committee or my fellow ranking member, but I know that it's been expeditious and efficient for this committee to try to get people to sit down together and just chat about a lot of these more mechanical things
Sure.
as opposed to policy issues. And you may not be able to like iron out all the wrinkles, but you might be able to iron out like 75, 80% of them. And then I know that there's people on this committee that are always willing to try to push the ball over the final finish line, you know, and figure out the other 20, 25%. So I just think that it would behoove everyone if you could like maybe sit down with Judge Bizzuto or her designees and just try to see where you can come to on some of these mechanical issues. That's just my 2 cents. But,
Absolutely.
other than that, you have very reasonable concerns. Thank you, Chairman Stafford.
Rep. Fishman?
Thank you, Mr. Chairman. Just continuing on with the restraining order, if the language in the other bill, I think it's the marshal's bill, on the electronic process, becomes law, would that ameliorate the concern about the, multiple counties?
I think it would facilitate the concern. I don't know if it would completely ameliorate the concern. So if they would have to report to the courthouse if they had one. I think the one little piece would be that perhaps the judicial branch would be able to help the applicant and email to the marshal, and then we're more than happy to help facilitate the transfer. It's their physical reporting to the court. The policy is a long-standing policy of us reporting to the courthouses. I don't think we really want to pull at that too much, but with the venue change, I think there might need to be a little give and take on that. So we just wanted to express our concerns on the record and on the bill at the time, you know, of the public hearing.
And I guess I do have concerns about the handoff on this very time sensitive documentation. So I guess it would not, I guess the judicial branch could decide to have 2 marshals appear at 4:30, you know, 1 for each county. I guess that's.
Yeah, that's probably a more complicated thing to put into place. I think the easiest thing to do would be to have the branch email it to the marshal. Right now, I believe as the statute is written and the dynamic is set up, it's the applicant themselves who arranges the service. So we don't want the applicant to be a victim of the system, so to
Yeah.
speak, getting the runaround.
Agreed, and that's why I wanted to ask you, does the language in the marshal's bill permit the court from sending it directly to the marshal?
It would actually enable it because the court would probably fall under the definition of a public agency. I think the issue is, will the court do that? We would like the court to do that, especially in this judicial district.
Okay, thank you. On section 29, if you could just explain
Sure.
a little bit clearer, or more fuller, your concern with the language before us.
So we would need to better understand the intention of the proposal. As I read section 29, it concerns writs of attachment, PJR attachments in a commercial waiver situation. And if you look on line 1572, it appears that such actions would be made returnable exactly 12 days after either the earlier of A or B, and I'm looking to B, service a process on any third person. So that would be an attachment, for example, at a financial institution. It appears that the case would have to be returnable exactly 12 days after the attachment's made. So process is generally returnable on a Tuesday. So if you backtrack 12 days, that would mean effectively all attachments would have to be made on Thursdays. And that only gives us 1 day to do it. That's just not practical for service of process. especially in cases that have multiple attachments, or sometimes these attachments actually concern physically seizing property like machinery. It just wouldn't be possible to do it on that timeline. So I'm not sure if that's a drafting error or a policy prescription. It appears that they want these returned under some sort of timeline. Whatever the timeline would be, we would suggest, the existing timeline of 12 and 6, returnable 12 days before the return date, not out more than 2 months. And that was what was in our testimony. But whatever's done here, we would need a workable timeline for service of process. My members' entire workflow is based on return dates and court dates. We both have piles of papers in the back of our car. They all have deadlines. That marks our workflow. So we would need a workable timeline here with
Okay,
these.
thank you. Thank you, Mr. Chairman.
Brian, let me just ask a couple of things on the TRO issue. We have existing situations where we have judicial districts that cross county lines. I mean, I'm thinking of the Milford Ansonia Judicial District, which is predominantly in New Haven County, but I think
Shelton.
Shelton, for example, is in Fairfield County, right? So how is the TRO issue currently being handled in that judicial
Right.
district?
So the examples you cite are few. This would add 6, so it sort of increased that dynamic. Currently, like the example you cite for Shelton, the New Haven County Marshal assigned to the Milford Judicial District would, if we got one for Shelton there, would transfer it to the Fairfield County Marshal. And that's sort of a service that we do uncompensated. It's just part of the deal. So as this sort of this proposal here would add 6 towns, we just wanted to get on the record from our Litchfield County Marshals that it would sort of increase that dynamic. But how it's handled, they transfer the order.
Okay. So there's a way to do it. It's just essentially right now they're not getting compensated for it.
Right. Well, I think the concern for the Litchfield County Marshals is they have the largest geography. So for example, I think you're based out of New Milford,
Milford, yes.
which is on the New York border. To call into the court and say, okay, we have one for you, to drive 70 miles round trip to go to the Torrington courthouse, and you can't even make the service. I think we just have to sort of work out that dynamic in the Litchfield Judicial District.
Well, that's actually another example, isn't it? New Milford, because isn't New Milford in the Danbury Judicial District?
We can do both. We can both do Danbury and this. Yes,
Okay.
yes.
Well, but a lot of the Danbury Judicial Districts in Fairfield County, right? So you do have a cross there too. So, okay.
Yes.
We have no problem moving the papers around the state. My marshals are quite adept at that. There's only so many of us. We have a network to do that. It's the physically reporting to court to do so in the Litchfield Judicial District that I think is the concern we're just expressing here today.
Okay. Understood. And then on section 29, I don't know how many folks are going to have testify on this, and certainly I'm not beholden to the language here, but I think the concern is we're seeing across the state, we're seeing a dramatic increase in the number of these, ex parte commercial waiver prejudgment remedy applications, oftentimes involving, frankly, parties that aren't even located in Connecticut, but they're signing loan documents that have a Connecticut choice of law, choice of venue in order to take advantage of what is a fairly severe prejudgment remedy process that we have in Connecticut that a lot of other states don't. And I think the fear is conceivably one could serve one of those commercial waiver prejudgment attachments, could push a return date out 2 months on a complaint, and then not return it until 12 days before 2 months out. And in that instance, you now have a prejudgment attachment that's out there for a solid 45 days plus, and there's no ability to contest it until the papers are returned to court. And so, because the way to contest the prejudgment attachment is by serving an ex parte order. So I think that's more on, a lawyer, frankly, playing games with the return date than it is probably with the marshals. But I think the intent of this language is to figure out a way to force the lawyer's hand to return the papers in a timely manner as opposed to trying to jam up the marshals.
Oh, absolutely. Yeah. Return dates, my whole life is run by return dates. So we get, just for normal writ summons and complaints, sometimes return dates that are only placed out 4 weeks, which effectively only gives us a handful of days to serve and return it. When attorneys ask us, what do you want the return date to be? I always tell them, put it out 7 weeks, please, and
Right.
I'll get it done and get it back to you. But it's when it's so tight, it's like the margin for error is so small. So, I mean, I completely understand the scenario that you lay out. If perhaps to tighten up how far the return date can be on these would be fine, but I would say it can't go less than 5 weeks because it's just unpractical for the routine flow of service of process.
Okay. All right, that's helpful. Further questions or comments? Representative Osborne?
Thank you, Mr. Chair. Made it here under the wire. Thank you very much for being here today. And sorry, I'm literally out of breath from walking up the escalator with a backpack and a briefcase. I wanted to specifically ask you about the geographic range of the Litchfield Judicial District in the context of combining it with so many suburbs of the Hartford County Judicial District. If one of the fixes was to permit Litchfield County marshals to serve these TROs in Hartford County, do you have any idea how long it takes to get from the Litchfield courthouse to the furthest reach of Simsbury?
That could be, it would depend where it is and what it is. It could be well over an hour. It could be a shorter amount of time.
Thank you very much. No further questions.
Can I just add something? Your problem on something like that would also be when you're thinking about bringing all of the Hartford County into Litchfield County, we do have Litchfield County to cover also. So when you have a TRO that, let's say, needs to go from our court up to somewhere like Lakeville, that is right at the Mass border. So there is no way when that marshal is on duty, there's no way we could get something served in a timely manner up in Lakeville and then have to go all the way, let's say, into Simsbury, if we were allowed to get that service done timely for the applicants.
So through you, Mr. Chair. So what you're saying is that if you had to go from one end of the district to the other, it could well be 2 or 3 hours in between.
Easily.
And also through you, Mr. Chair, do you know if there's any public transportation between Litchfield and these Hartford County suburbs?
I'm sure there are, but I'm not sure. I'll be honest. I know in Torrington there's Mass, where the courthouse is. There are, buses, and in fact, right in front of the courthouse there is. As far as how far they go from Hartford to Litchfield, I have no idea if they even do that.
So if there is no public transportation, an applicant who may be able to get from Terriffill or Simsbury into Hartford via public transportation could not do the same thing to seek a TRO in Litchfield?
Correct.
Thank you very much. Through you, Mr. Chair.
Further questions or comments? If not, thanks for being with us, guys.
Thank you.
Judge Beverly Street.
Good morning. I'm Beverly Straight, the probate court administrator. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. I'm here this morning to testify on Raise Bill 1501, an act concerning the probate court operations. Thank you for raising the bill. I'm here in support of the proposals that have been submitted on behalf of the probate court system, specifically sections 1 through 6 of the bill. Section 8, we worked with the proponent. I have no concerns, but take no position with respect to the proposal. Section 7 calls for a feasibility study. My concerns I expressed in my written testimony. My main concern, frankly, is the timeline by which such a study and a report would have to be submitted due to limited resources in my office to undertake a comprehensive study at this time. Certainly, I'm not opposed at all to the concept. I'm happy to answer any questions.
Questions from the committee? Judge, when could you provide the report outlined in section 7?
My understanding is that the proposal includes the Commissioner of Social Services. We have not yet had a response from their office on their resources and involvement in it. And I understand the Connecticut Hospital Association would also like hospital members to really undertake a complete comprehensive study. I would respectfully request an October 2027 deadline. It would give us approximately a year and a half so that we could make sure that the study was fruitful.
Problem with that is it wouldn't provide insight back to the legislature before our next legislative session, which is normally what we do on studies like this.
My thought process was to ensure that we had the length of time to actually study it comprehensively, given the magnitude of the conservator statutes, with an eye to the following session to present to the legislature for any proposals that might be recommended. I can tell you that a significant factor is going to be with respect to the compensation rates. The committee may be aware the rates are relatively low compared to other professionals appointed in the probate court system and in the judicial branch. Yet we do not have the resources to expand those. So the fiscal note may be a concern.
Questions or comments from the committee? Representative Osborne?
Thank you, Mr. Chair, and I promise I won't make a habit of this today. Thank you so much for being here. I wanted to ask you a little more specifically about the rates of conservator compensation in the probate court. You said that they're lower. I took a look at this issue recently. It's substantially lower than even public defender contract work case. From what I'm understanding, it's something like $40 an hour to an attorney.
The rate for a conservator is $52 an hour. You are not required to be an attorney, but many are. So absolutely, in terms of an hourly rate for an attorney, it's very low. If services that are set forth in our regulation are actually performed by staff, then that hourly rate is $26. As opposed to a court-appointed attorney in the probate court system is paid $58 an hour, which is also significantly lower than the contract public defenders.
So I'm sure you have knowledge of what paralegals and attorneys are paid on an hourly basis. My understanding is that paralegals in general are compensated anywhere from $40 to $70 an hour right now. And attorneys are upwards, at the conservative end, upwards of $300 an hour in private practice in this area. Is that true to your knowledge?
I am not aware of current market rates in the private sector.
But to the extent that a staff member is only being compensated at $30, that would actually be a loss for the practice that was employing them, correct?
I think mathematically, yes. It's not clear to me that conservators who have staff are actual paralegals or have other disciplinary training.
Thank you so very much for your input on that. I really appreciate it. Thank you very much, Mr. Chair, through you.
Further questions or comments? If not, thanks for your comments.
Thank you.
Rob Rosado?
Good morning, Chairs Winfield and Staffstrom, ranking members Kissel and Fishbein, and honorable members of this committee. I'm Rob Rosado, Chief of Police of the Meriden Police Department and also President of the Connecticut Police Chiefs Association. We'd like to offer our position on the following bills that impact public safety and our profession. House Bill number 7258, an act concerning driving under the influence while consuming cannabis. CPCA has provided written testimony strongly supporting this bill, which will amend the existing statutes to allow law enforcement officers to stop a motor vehicle when officers detect an odor of cannabis, and when the officer observes an individual operating a vehicle consuming cannabis. This is a common sense change necessary to enhance roadway safety and uphold the integrity of traffic enforcement in Connecticut. It is entirely reasonable and necessary that the same standard as consuming an alcoholic beverage be applied for the use of cannabis. House Bill number 7260, an act concerning excessive reckless driving. CPCA has provided testimony regarding the urgent need for stricter laws and more consequences for individuals who engage in reckless driving and dangerous motor vehicle pursuits. The opportunity for an increased penalty for a second offense will be helpful to correct the reckless driving behaviors by repeat offenders. It could also serve as a deterrent for motorists, which can lead to a reduction in motor vehicle accidents causing injuries or fatalities. House Bill number 7259, an act concerning revisions to the various statutes concerning criminal justice. We support Section 70 and 8 of this bill as proposed. The new electronic defense weapon, also known as tasers, are seen by law enforcement as a valuable tool in dealing with certain calls for service and a less lethal option for officers. The language in these two sections helps clarify the deployment of an electronic defense weapon does not qualify as a deadly use of force, causing an investigation by the Inspector General's office. Section 14 of that bill is something that CPCA believes needs to be changed. A tiered approach to those that disregard an officer's attempt to initiate a traffic stop is something CPCA believes is fair to those that might not be aware that they are being stopped. However, reducing the level of a class felony for a second or greater offense that causes the death or serious physical injury to another person is counterproductive to making Connecticut's roadways safer. In conclusion, with the rising fatalities and significant injuries sustained as motor vehicle accidents, it is time to improve highway safety and restore accountability. There is growing frustration among law-abiding citizens, motorists, and victims of these accidents. Therefore, legislation must restore motor vehicle laws, classify laws accordingly, and hold violators accountable for their actions. Thank you.
Questions from the committee? Representative Howard?
Thank you. Good morning, Chief. So jumping back to 7258, which is the marijuana driving or cannabis driving legislation. So the current law is that it's illegal to smoke marijuana while driving, right?
That is correct.
But your officers are prohibited from stopping somebody if that's the sole reason for the stop. Is that law violation?
That is correct.
So this would seek to undo that. One question I have is going down to section 4. It says that any of the existence of the following circumstances shall not constitute in part or in whole probable cause or reasonable suspicion for a stop or search of a person or motor vehicle. And it says the odor of cannabis, but then it goes on to say unless a law enforcement official observes active consumption. So we're in agreement that if a police officer pulls somebody over, say for speeding, and they smell marijuana, and everybody, or at least one person in the car is over 21, there's no probable cause of a crime, right?
It could lead to an officer performing a field sobriety test and possible operation of under the influence.
Right. But I guess my point is prior to the legalization of marijuana, the odor of marijuana was probable cause to search a car under the Carroll Doctrine. We agree on that.
Correct.
But now that we've legalized it, simply the odor of marijuana or the presence of marijuana, if it's not actively being smoked, is not a crime, and therefore the smell of that really shouldn't constitute probable cause to search a car, right?
That is correct. It is not probable cause to search a motor vehicle.
All right. And then, so under current law, absent this, if a police officer stops somebody for speeding and smells marijuana, they can still pull them out for field sobriety test today, right?
That is correct.
But what we're trying to do, as I understand it, is say, well, if a person is committing no other violation, right? And they pull up next to, it's a summer day, and they stop in a 2-lane road next to a police officer, windows down, they're it looks like they're smoking a joint. The officer can see it. They can smell marijuana coming from the car. They can't stop that car for solely that, right?
Correct. Under this new law, it would allow the officers to perform that motor vehicle stop.
Even though that is a violation of law. Right? So currently it's a violation of law, but the officer can't stop them solely for that, right?
Correct.
But we don't want to make it so that officers can search cars based solely on the odor of marijuana if it's not being actively smoked because there's no other crime. But if somebody pulls somebody over and if this were to pass and one of your officers stops somebody and they're actively smoking marijuana, the search, why would a search then be necessary to find evidence of that? In other words, more marijuana, or do you think a search is really necessary in that circumstance, assuming the person's over 21?
The search would be necessary to basically find the evidence of the crime and seize that as evidence. So just like if an officer observes an individual drinking alcohol, we would seize that container itself. So it'd be the same manner.
So today, if I'm drinking a beer driving down the road, which I don't do, but if I did, and one of your officers saw me and goes to pull me over, and then I take what he saw and I jam it under my seat. Under current law today, he observed a violation. He saw it was in my hand. He was behind me. It didn't fly out the window. He can search my car to look for that evidence of that offense, right?
That is correct.
But in marijuana, he can't do that.
Marijuana, we cannot do that.
Okay. And then, you talked about field sobriety tests, and it's not specifically addressed in this language, but I think it's important in another bill. But how many of your officers are trained to, because the alcohol standardized field sobriety test, I assume all of your officers are trained in those, right?
They are all trained in that.
How many of them are trained in detection of under the influence of marijuana?
So we have no DRE officers, drug recognition experts within our police department. They're very limited throughout the state of Connecticut.
Right. So they're limited throughout the state. So that's sort of, and to my knowledge, and I'll ask you, are there any standardized field sobriety tests, roadside tests for marijuana like there is for alcohol?
No, there's no specific test to identify the marijuana in comparison to alcohol.
Right. So, and the reason I ask that is because some folks have made an argument and said, okay, if an officer observes somebody smoking marijuana and driving, which is illegal, they can't pull them over for that violation, but they can pull them over in a suspicion DWI and take them out and test them. But what tests? Like in Meriden, how can a police officer in Meriden, if you have no DREs, say, well, I pulled them over to run them through tests, but I don't have any tests to run through? It's kind of an illegal stop, right?
So you'd have to have observations of other motor vehicle violations to perform the motor vehicle stop. And based on that, you could perform the test. But there's no specific test for marijuana. If the individual fails a field sobriety test, roadside test, then the individual can be arrested, and then a urine sample could be taken from that individual at headquarters.
Do people fail the standardized field sobriety test if the only thing they have on board is marijuana? Is there any science to that?
No, there's not.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Further questions or comments from the committee? Representative Quinn?
Thank you, Mr. Chair, and Chief Rosado, thank you very much for being before us today. Can you cite any specific examples that have happened in Meriden that the changes to 7258 through 7260 would address favorably?
So certainly 7260, we had a number of individuals come through our city and do street takeovers. That's certainly all those individuals involved in those violations are usually recklessly driving. So they're leaving or coming to the city of Meriden, driving recklessly through the highways, stopping, taking over an area, and then leaving. We're just not the only community that's impacted by that. You look along New Haven, Rocky Hill, Vernon, Berlin, Hartford, a number of communities throughout the state of Connecticut have been impacted by this. And this is one way to kind of avoid or kind of deter that type of behavior by enacting stiffer penalties. In regards to 7258, We smell marijuana constantly through the city of Meriden. You drive, you could probably say that for any community. You drive down the road and you could smell that odor. Sometimes you do see the individuals consuming that cannabis. So there's violations there constantly throughout the city of Meriden, but that could be the same for anywhere in the state of Connecticut. And in regards to 7259, 7259, so the various statutes concerning criminal justice, we've had a number of motor vehicle accidents in the last couple of years that were impacted, where individuals are seriously injured or fatalities occurred. So we've had a number of those crimes occur in the city of Meriden.
And going back to 7258, Section 4, line 70 and 71, where it talks about observing the actual consumption of cannabis, how likely is it that it would actually be observed? I mean, I think that this starts to take it in the right direction, but I'm not sure that it goes far enough. If the actual observation needs to happen, because certainly that isn't a criteria for alcohol.
So yeah, I can't give you numbers. I don't have data, but I could tell you that there's a number of individuals that drive around and are doing it purposely, or they do it disregarding laws, and you could see them sometime consuming the cannabis. But I can't give you an amount of times it does occur.
All right. Thank you very much.
Thank you.
Further questions or comments? Representative? Oh, Representative Callahan, sorry.
Thank you, Mr. Chair. Chief, thanks for being here and always engaging with us.
Thank you.
I've seen you in other committees as well, so I appreciate it. I'm trying to, for my own knowledge, fill in the blanks with what Representative Howard and Representative Quinn have asked. So you said you have no DREs, but I would assume that your officers have been trained. Everyone knows what the smell of cannabis is.
That is correct.
Okay. And you just said in response to Representative Quinn that you observe it quite often. Really, since we've legalized, you can smell it everywhere, but you can observe it, whether it's at a stoplight, whether it's a slow moving traffic in a 25-mile-an-hour zone. But so you can actually observe people doing it. And in your opinion, are citizens aware that, this is in your professional opinion, that they can't be stopped for that?
That is my opinion. People know the laws. Unfortunately, sometimes better than the officers themselves. So they know the laws and they understand that they can't be stopped for it. And they purposely do it, I think, for that reason.
Well, thank you. And I assume that it's got to be frustrating for police officers like Representative Howard and yourself to observe it, know it's a safety risk, and yet not being able to do anything about it. You're nodding, so I'm assuming you agree with me.
I do agree with you. It is frustrating. It's more frustrating because we have a lot of citizens. We go to a lot of community events. We have community policing meetings, and they voice their opinions, and they're frustrated with it as well. So we're not the only ones frustrated with it. Your local citizens throughout the state of Connecticut are also upset with this.
Thank you. My last question, Mr. Chair, is this. If you've said that with some blood tests have been taken and there's been accidents, I'm just curious if you're getting the, I worked with probation. I took the fun part of the job, a lot of urine tests, but so there's certain levels of THC, and I'm sure, are they appearing in some of the tests?
I don't know off the top of my hand. I know on one fatal motor vehicle accident, it did appear that we had in Meriden probably a couple of years ago. It did appear in that.
Well, I certainly appreciate you coming up and testifying. Thank you, Mr. Chair. Appreciate it.
Thank you.
Senator Winfield.
Mine is just to clarify, because I just want to be sure I heard what you just said. You said that you believe that the people of the state know the laws better than the police?
I believe that the individuals in the state of Connecticut are very aware of their laws here in the state of Connecticut.
Yeah, my question was, did you say that you believe that the people of the state know the laws better than the police?
I did state that but it's making a reference to the individuals in the state of Connecticut themselves, knowing the laws very well.
That's a little bit shocking to me because I encounter folks all the time who have no idea what the laws of this state are. But I just wanted to clarify that's what you actually said. Thank you.
Chief, let me just ask, so, I think it's important just sort of to consider kind of the interplay, right? And that's oftentimes we look at these bills, we look at them in isolation, but we got to look sort of at the overall penal code and how stuff fits together. So if I've got somebody driving down the street today, state of Connecticut, and officer pulls up behind them and they smell what they believe to be the smell of cannabis. They observe what they believe to be is a joint in the person's hand. And the person has an easy pass on their windshield. Can the officer pull that car over?
Easy pass on the window obstructing
Just
the
an easy
view.
easy pass sitting there underneath the rear view mirror. Can the officer pull that car over?
Technically he could.
Okay, so same scenario. Somebody driving down the road smoking what they believe to be cannabis. There's believe what's a joint in their hand, and they've got a frame around their license plate that says the college they went to that's obstructing the word Connecticut. Can that car get pulled over?
If it's obstructing the license plate, he could be pulled over, yes.
Okay. So what about you've got a car driving down the road again? Maybe you don't smell cannabis, but maybe somebody's got something in their hand that you think might be a joint. And all of a sudden they start slowing down and then speeding up and then slowing down and then speeding up. Can that car get pulled over?
If he's going over the speed limit, yes, he could be pulled over.
Okay. What if they started to veer across the line?
Yes, they could be pulled over for veering across the line.
See, because I just think, look, I honestly, I don't have a huge problem with the language before us. I think it's, you know, frankly, I'm not sure it's necessary. I think it's sort of existing law. I think we know there are 600 some odd equipment violations that a car can be pulled over for. We know a car can be pulled over at any time because somebody's believed to be driving erratically, you know, maybe they roll through a stop sign. I think this notion that sort of a car can't be stopped when a cop, quote unquote, knows somebody is smoking cannabis, I don't buy it. You know, I think that there are so many other reasons the car can be pulled over. So the language before us, I guess where I'm at is I don't necessarily see a problem with it because I think, like I said, it's already law. I mean, there's so many reasons that a car can be pulled over when a officer believes they smell cannabis. It might not say in the statute book you believe you smell cannabis, but let's face it. I mean, the cop can find a reason to stop a car if they want to stop a car. So I guess maybe that's more comment than a question to you, but maybe I'll put it to you. I mean, why am I wrong? I mean, why is this particular language necessary given sort of all those other reasons that a car can be stopped?
So I'll give you the main reason. It's to protect the individuals, other citizens, other motorists. It's to improve public safety. Our goal is to stop operators who may be under the influence before an incident occurs. So why wait for a violation when we could actually pull the individual over when we see this and also smell it?
I hear you, and I think that sounds good. I guess what I'm saying is I think it's probably a very rare occurrence on our roads that there's not some reason a cop can't pull the car over if they want to, given the number of equipment violations we allow people to be pulled over for, and you know, we see it. So thank you. Thanks for being with us
Thank
today.
you.
Lily Cummings will be next. Good. I think we're good on questions.
Okay.
Thank you. Appreciate your time.
Thank you.
Thank you, Chief. Lily Cummings will be next. No? Okay, how about Beth Hamilton?
Good morning, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. My name is Beth Hamilton, and I am the Executive Director of the Connecticut Alliance to End Sexual Violence. The Alliance is the state's coalition of community-based sexual assault crisis services centers who provide crisis intervention and support to survivors of sexual violence, including 24/7 hotlines, counseling, support groups, accompaniments in hospital, police, and court settings, legal representation, and post-conviction victim services. Sexual violence remains a public health epidemic. Over half of all women and almost 1 in 3 men will experience some form of sexual violence in their lifetime. While sexual violence is incredibly prevalent, sexual crimes are the most underreported crimes in the United States. On average, less than 4% of reported rapes, sexual assaults, and child sexual abuse result in a conviction in cities across the United States. Most victims do not report sexual assault crimes to the police. In fact, the U.S. Department of Justice estimates that more than 2 out of every 3 sexual assaults do not get reported to police. Victims and survivors share that they did not report out of fear of the perpetrator, concerns about confidentiality, uncertainty about being believed or blamed, and/or fear of negative consequences such as retaliation, arrest for illicit drug use or underage drinking, or deportation. The Alliance strongly supports lines 1 through 98 in HB 7259, which will add the category of identified to the state's options for the collection and processing of forensic evidence in sexual assault crimes. The creation of a pathway for victims to choose to have evidence from their sexual assault kit processed without a required police report will allow victims to make informed decisions. Reporting to law enforcement can be a barrier to survivors who want more information or time before deciding if and when they want to engage with police. For some survivors, the presence of DNA evidence is critical to their decision to move forward in the process. Currently, 5 states offer victims the ability to consent to testing of forensic evidence from their sexual assault kit prior to deciding whether to engage police. In these states, DNA evidence from non-reporting sexual assault kits aid the criminal legal system in identifying and holding perpetrators of harm accountable, and DNA evidence has allowed law enforcement to identify serial sexual offenders and solve cold cases. The additional testing will provide vital information to survivors and the criminal legal system with minimal use of additional resources. The DNA evidence analyzed as part of an identified sexual assault kit will continue to be handled in the same manner as is currently in statute. However, survivors could have access to information about the presence of DNA evidence, allowing them to make fully informed decisions about engaging in the process. I urge you to pass HB 7259 to remove barriers for survivors, increase forensic evidence collection, improve forensic evidence collection, and enhance public safety throughout the identification and prosecution of sexual offenders. Thank you for your time.
Questions or comments from the committee? If not, thanks for being with us, Beth.
Thank you.
Robert Devlin.
Good morning, members of the Judiciary Committee. Very nice to see all of you. My
see
name is
you.
Robert Devlin. I'm a retired judge and presently Inspector General for the state of Connecticut. And I wanted to appear here today to testify in support of Section 9 of House Bill 7259. This bill would make a technical amendment which would allow the use of a chokehold not only to defend oneself, but also to defend a third party against deadly physical force. We had a case in the Inspector General's office where a state trooper was on duty and got a report of a rolling domestic violence. Or a woman complained that she and her minor child were being essentially kidnapped by this fellow in this car. And the trooper proceeded to try to pull the car over when I-95 meets I-91, and the car sped off. There happened to be an off-duty trooper who was just in his police car, but did not have any of his equipment, who overheard the radio transmissions and came to the assistance of the uniformed trooper. And what happened, the car exited the highway in Wallingford. The subject fled on foot. The trooper attempted to apprehend the person, and they got into a physical struggle, and the subject got the trooper into a chokehold next to a guardrail. About that time, the off-duty trooper arrived and found this situation. All he had was his gun, didn't have his taser, didn't have any of the other equipment that he usually has. And so he put a chokehold on the offender to get the trooper released. And no one got really hurt, and the person was arrested and the case proceeded. So the use of a chokehold, the use of deadly force in Connecticut. So it came to my office to write a report on that. And when I started writing the report, I realized that the statute, when the Police Accountability Act was passed and chokeholds were considered deadly force, it allows someone to defend themselves from the deadly force by using a chokehold, but not a third party. And I thought that was basically just an omission in the law. And when I wrote the report, I indicated that I'd try to bring this to the attention of the legislature to see whether or not a clarifying amendment might be possible. And that's why I'm here today. I think this statute is a simple change. I think it will actually strengthen the law, and I urge its passage. Thank you for your attention.
Thank you. Representative Howard?
Mr. Devlin, in the scenario that you just posed, if the off-duty police officer is carrying his firearm and shot that individual, would he have been justified?
Yes.
So as the language was drafted in the police accountability bill, for that peace officer to have been in compliance with law, he probably should have shot him.
Well, I don't think the legislature intended that. And why would you, I mean, as a matter of technical law, yes.
That's what I'm asking.
Yes, correct.
Yeah,
you're right.
I wasn't asking intent. I don't
Right.
think you were in the legislature then, so I wasn't gonna ask you the intent, but I'm trying to drill down. So as it writes right now, for a police officer to have been in compliance with law, technically, it sounds like your office chose not to prosecute that individual,
Correct.
even though technically he's in violation of law.
Well, of law, our general self-defense law would permit the use of deadly force to defend yourself or a third person. And state police regulations allowed you to do that. So this
Okay.
officer was in a situation where there's conflicting law that he was trying to navigate through.
Well, that's what I'm getting at, right? So, and so under current law, we've sort of set them up in a not a good situation, right? Because theoretically, absent this change in section 9, we're sort of, there's a law that's almost requiring a police officer to be in compliance with law to use a level of force that isn't necessary. Is that fair?
It is fair to comply with the Police Accountability Act,
Right.
but as I said before, our general justification law, our general law of self-defense would permit what the officer did in that situation.
Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments? Senator Winfield?
Then what was the basis for the decision you had in the case that you dealt with?
I ruled that I felt that the general law of self-defense, which permits a person to use deadly force to defend themselves or a third party, was appropriate to apply in that situation. I also felt that the state police regulations specifically allowed the trooper to do what the trooper did. And yes, we had this anomaly with respect to the Police Accountability Act, which didn't seem to permit it. So I was in this sort of confusing area, and I didn't think from the point of view of the trooper, given the fact there was a confusion in the law, it would be appropriate to prosecute that person under those circumstances.
And I just want to understand. So I'm asking a question that I honestly want to get an answer to. What is the confusion? I don't think I read it the same way. So I just want to know. I think my reading allows for them to do it. So what about it is the confusing part, right? It seems to me in the case you're talking about that there wasn't an alternative. The level of force was necessary to do all of the things in the law. So what is the confusion?
In the Police Accountability Act, when a chokehold was classified as deadly force, the law says you're allowed to use a chokehold to defend yourself from deadly force. It does not permit you to use a chokehold to defend a third party from deadly force. That to me is the inconsistency.
Maybe I'm reading from the wrong place, but he or she reasonably believes such use to be necessary to defend himself or herself or a third person from the use of imminent use of deadly physical force.
Right, that's the amendment, and that's what I'm asking that this committee approve.
No, but I'm reading not from the amendment. I'm reading from the statute.
I don't have the statute in front of me, but I have the bill, and the bill indicates the underlying portion there is the portion we're asking to add.
I get that, but I guess I need to go back and look because as I pull up the statute, it seems like that sits there. So I will double check, but that's why I'm confused about your confusion.
Yeah, all I can say this, Senator Winfield, if it's in there, then I don't need to be here. I think it.
I agree. I would agree. I'm not fighting with you. I just want to make sure that we are all
Sure.
in the same place. I think I don't think there's disagreement that if a situation like the situation that occurred, that the officers should be able to act. So I just want to make sure that I'm clear about what brings you here.
Sure.
And now I will go and clarify and we'll figure it out. Thank you.
Okay, great. Thank you.
Further questions or comments from the committee? Further questions or comments? If not, thanks very much, Stretcher.
Thank you.
Barbara Fair.
Good morning, members of the Judiciary Committee. My name is Barbara Fair. I'm a licensed clinical social worker and a director of Stop Solitary CT. I submitted written testimony, and so you know which bills I support. So I want to take you on a short journey with my 3 minutes. On March 25th, 2018, a young man was suffering a mental health crisis. A clinician determined he needed to be monitored in the behavioral health unit at Garner CI. He went into the unit with several correctional officers. He was handcuffed behind his back and shackled on his ankles. Per DOC policy, he was stripped naked in order to get on his knees to submit to a strip search. He said he couldn't do it. He was ordered again, this time stating either you do it or it'll be forced. He again said he couldn't do it. After being stripped naked, a bag was placed over his head and he was sprayed several times with a chemical injected with various medications. Within an hour, he was in Danbury Hospital where he was pronounced dead. He was received in the hospital with handcuffs on both wrists secured close together, as well as a chain extending from his hands to his feet, which were also cuffed, and he had an approximate 12-inch chain looped between the ankles. Medical records indicate dry blood to his face and mouth, blunt trauma to his head and extremities with abrasions and contusions on his eyebrow region, lips, right and left arms, hands, and wrists, and one reported his neck was broken. A janitor stated, indicating, I saw them beating this kid and I heard him saying, "Dear God, let me go." He was later tasked with cleaning up the room where he observed a mattress in a cell with a lot of blood on it. That man was Jalen Jones. His death was ruled a homicide. But on 1/24/2019, Chief State's Attorney Zadinsky closed the case after finding Jalen's death was of non-criminal nature. Several violations of DOC policy were found. Recommendations were made to expand trainings. Not one person was charged because those viewing the video found his death was non-criminal. For the past 7 years, his mom's been fighting to have that video beating death of her son exposed to the public, while the state's attorney and attorney general have fought to have the video sealed. Now you can turn a deaf ear and a cold heart toward me, but it won't change the facts. This man, completely defenseless, was beaten to death by the very people who come into this building declaring the PROTECT Act made their job dangerous. And they just need more money and more staff and overtime, including their pensions. Despite their narrative that their job is so dangerous, they are not the ones leaving there in body bags. Every year, according to the Inspector General report, incarcerated people are leaving there in body bags, many by suicide, drug overdoses, others undetermined natural causes and medical complications. Many become defenseless when I say this is a department that dehumanizes, degrades, and breaks the spirits of vulnerable people. I know I alone can't change what's going on behind these bars, yet I won't be complicit by being silent. While lawmakers come into this building to pass laws on civilians, I just got another
Barbara,
sentence.
let me
And
just-
some of them,
Barbara, let me just ask,
oh,
what bill are you testifying on?
oh, I'm sorry, because I had already submitted. That's,
Yeah, no, right, but I'm trying
okay,
to figure out what your
sorry.
testimony relates back to.
HB 1549, 7255, 7257, and 7259, and 7261, all about studying laws and statutes.
Okay, and what's your position on those bills?
Pardon me, I support this study.
Okay, good.
But the one thing I did want to say, which is the way I was ending this, I'm cautiously optimistic that this working group looking into the laws that govern this state will bring change. The one major missing party in the group are people with lived experience. They're the true experts in knowing what's wrong and what needs to be corrected.
Okay, great. Further questions or comments? Senator Winfield?
Yeah, I feel like since you've been engaging
Pardon?
us, I feel as though since you've been engaging us for so many years, it's always incumbent upon us to thank you for continuing to show up. I know it becomes difficult sometimes to do that, but it is an example to folks of the importance of persistence. Thank you.
Thank you. Like I said, you could turn a deaf ear on me, it won't change the facts.
Oh, you won't let us do that now, Barbara, will
No,
you?
not at
All
all.
right, thanks for being with us. Lisa D'Angelo.
Good morning, co-chairs Winfield and Staffstrom, ranking members Kissel and Fishbein, and esteemed members of the Judiciary Committee. My name is Lisa D'Angelo, and I am an Executive Assistant State's Attorney at the Office of the Chief State's Attorney. I am here on behalf of the Division of Criminal Justice, which is in broad support of Sections 1 and 2 of House Bill 7259. Section 1 of the bill seeks to revise provisions of the DNA Data Bank. The DNA Data Bank is comprised of known DNA profiles of individuals convicted of certain offenses, as well as DNA profiles obtained from evidentiary items submitted to the Connecticut State Forensic Laboratory for analysis. The DNA Data Bank regularly compares these profiles to one another, and the lab will receive a notification when there is a potential match of 2 or more profiles within the data bank. If the match involves one of the known DNA profiles in the data bank, the DNA Oversight Panel will verify that there is a qualifying offense prior to sharing the information. If it is determined that the individual's profile should not have been in the databank, pursuant to statute, the DNA profile is purged from the databank and the match is not shared. Under present law, there is no mechanism for a match under these circumstances to be shared with an individual or his or her attorney who has been charged with or convicted of a crime when this information may be favorable to his or her defense. Section 1 of House Bill 7259 would allow for a procedure when this situation occurs. Section 2 of House Bill 7259 seeks to revise provisions of the sexual assault evidence collection kits. Under current law, treating healthcare facilities can collect evidence using a standardized sexual assault kit whenever a patient identifies themselves as being a victim of a sexual assault. Currently, there are only 2 categories the kit can be classified as after the evidence is collected. Reported, meaning that the patient has made a report of the alleged sexual assault to law enforcement, or anonymous, meaning that the patient does not want their name associated with the evidence collection kit and did not report the alleged sexual assault to law enforcement officers at the time that the evidence was collected. Those evidence collection kits categorized as reported are sent to the lab for analysis, and those categorized as anonymous are sent to the lab and held for a period of time and not tested. Adding the third category of identified would address the situation in which a patient would like the evidence collected to be analyzed by the Connecticut State Forensic Laboratory, but does not wish to make a report of the alleged sexual assault to law enforcement at the time the evidence is collected. Section 2 of House Bill 7259 will allow for the trauma-informed practice of giving patients the option to have evidence collected and to decide at a later time whether they wish to make a report to law enforcement. In addition, Section 2 of House Bill 7259 would also allow the Connecticut State Forensic Laboratory to return evidence from the standardized sexual assault kits or any portion of such evidence to the submitting law enforcement agencies. This is currently the practice with all other evidence submitted to the state lab. For these reasons, the Division of Criminal Justice is in support of Sections 1 and 2 of House Bill 7259. The division has also submitted written testimony with regard to these and other parts of the bill. Thank you.
Questions from the committee? Representative Howard?
Lisa, good morning. Thank you. I just want
morning.
to clarify
Yeah.
for my colleagues, 2 things. One, so in section 1 right now, when there's a new submission or a submission and so I'm a police officer, right? So if I send DNA to the lab and they say, okay, we have a hit, it's, Joe Smith from Stonington, but they recognize immediately that that DNA shouldn't even be in the system. They don't share that information with me currently, correct?
Correct. If you got the information that there was a hit, it means that the DNA Oversight Panel had verified that that individual was properly in the data bank.
Right. So, so if I send DNA to the lab and they get a hit, but they determine that submission shouldn't be in the data bank at all, I'll never know that, right?
You will never know that.
And as I understand it, the problem with that is they could say, oh, wait a minute, this is actually going to be exculpatory. So exculpatory meaning evidence that this person didn't commit a crime.
Correct.
And under current law, they can't share that with me either.
Correct.
What this change is basically saying, all right, look, if if we get a hit and we realize that that information shouldn't be in the data bank, if it's going to be used to implicate somebody, we're not going to share it because that violates their rights. It shouldn't have been there. However, if it's going to be exculpatory in the interest first of not convicting an innocent person, we will share their information. That's what this change would do. Is that fair?
That is correct. It will give us the authority to share the information.
Okay, and then jumping to section 2. Thank you for your testimony, if I didn't say that already. On section 2, so what we're trying to do there is basically, and we all know that sex assault victims are a very special case, right? I think we all know that in this committee. Certainly I do, certainly you do. Sometimes sex assault victims are hesitant to report because they don't think their case will be proven. Is that fair to say?
Yes, in my experience in talking with other advocacy groups and law enforcement, yes.
So what we're basically saying is that we're going to create an avenue where that individual can have the evidence tested first so that they can feel more confident and more empowered to make their complaint. Is that fair?
That is fair. And it's also for an investigative tool. If there's a serial sexual offender out there, the profiles can be linked from crime to crime as well, regardless of whether that individual survivor reports the alleged sexual assault.
Like a good attorney, you anticipated my next question. So thank you for answering that as well. Thank you, Mr. Chairman. Thank you so much.
Thank you, Representative.
Thank you. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you for joining us.
Thank you, Senator.
Cindy Prezio.
I canceled yesterday.
Oh, okay.
Thank you.
Josiah Schlee.
Hello, I'm here. One second. I apologize. Can everyone hear me okay?
We do hear you. You may proceed.
Uh, good morning to the honorable members of the Judiciary Committee. My name is Josiah Schley. I'm a member of CT Cannon Warriors. I'm here today in opposition of Raise Bill 7258. And I just want to tell you from experience, as someone who's arrested, stone cold sober by a drug recognition expert in Windsor, I believe 16 MAD awards. He leads the department in arrests. He's a drug recognition expert. I was pulled over. I'm a concert photographer, so I stand front row at a concert around people who are smoking cannabis, spilling beer on me all night for 4 hours, staring through a camera lens. So when I drive home, I'm exhausted. I smell like burnt cannabis from other people. People spilled beer all over me. And then I'm on the way home, stone cold sober. I get pulled over by this drug recognition expert. I'd blow zeros. All of a sudden, they smell cannabis. There's no cannabis in my car. And then I fail nystagmus because I have an eye issue, an eye tracking issue. So how is it fair for me to suffer based off, what happened around me at a concert? And I've also included a study in my submitted testimony that from AAA that THC is active in the blood 24 to 48 hours after abstinence. So blood is just not an accurate metric at all for current intoxication of cannabis. And neither is just the smell of burnt cannabis. That's why I think the roadside sobriety tests and the things that Staffstrom had mentioned are already in place are the most effective and fair ways. I had to spend 13 months in court fighting these charges. I had to fire a lawyer that cost me $3,500 because he wanted me to plead guilty. And I had a pro bono lawyer take me up, thank God, and go to court with me for 13 months with state forensic crime labs of 0% THC, 0% alcohol, nothing in my blood. I still had to spend 13 months in court. I couldn't get a job anywhere. The day after they dropped the case, I got a job working for the state as a park ranger. So I would really appreciate any questions or any clarification you have on this stuff. I'm totally against driving under the influence of any kind, but I think laws are already in place that cover this. And just like my story, there's so many situations. I was just working, happened to smell like burnt cannabis because of what people were doing around me. I smelled like alcohol because people spilled beer on me. And, I had my life really messed up. I've never recovered from that bump in my work from this. I was doing my job and I was following the law, and it ruined my life for over a year. So I just think you need to look at how that affects people.
Thank you. Comment or
Thank
question
you.
from members of the committee? Comment or question, Representative, I just went blank. I hate when that happens.
Osborne?
Osborne, thank you.
I'll remember that and use that later, Mr. Chair. Thank you so much, Mr. Chair. Good morning, Josiah. It's good to see you here in Judiciary as opposed to simply the usual place I see you over in general law. This is a thorny issue that we're grappling with as a community, as a state legislature. And I know that you come to these conversations in good faith. So I really appreciate that. And I'm wondering what ideas you have, because obviously we do have a problem with people driving while either actively smoking marijuana or while driving in a car where others are actively smoking marijuana. And, I've been to concerts. I understand how contact with cannabis smoke works. And, we have an important job to figure out how to do that, because we do have problems with increased accidents and fatalities in our state. And I'm wondering, if you were sitting in my seat, what would you do about that problem? Knowing that you are, a cannabis warrior and you're an advocate for cannabis, how would you thread that needle as we're sitting here so we can curb people who are actively using and driving high and keep our streets safer while avoiding the problems that you experience? Thank you, Mr. Chair, through you.
No, I appreciate that very much. I think as it stands, really the most accurate metric is observing erratic or unsafe driving. And then when they pull someone over, I think it was Staffstrom, and I forget who he was speaking with at the time, said that, there's a ton of different violations that can lead to a search if needed or roadside sobriety if needed. And I really think roadside sobriety, my nystagmus issue is unique to me. A lot of people don't have that issue. So normally, I think roadside sobriety is really the best metric to stick with. That's the safest to identify people. And I also noticed that all the billboards in the state, like, if you feel different, you drive different, like about driving high, where did all those go? Like, where are all the billboards with education reminding people not to drive high and just to be responsible users? Because the blood doesn't work as a metric, the how I appear doesn't work as a metric. My eyes could be red, I could smell like cannabis from something else, I could smell like cannabis for legally working in the industry based off the odor just coming home from work. I really think it needs to be roadside sobriety and observed erratic or dangerous driving. And then the officer can then take that route after approaching the window, whether they smell burnt cannabis based on how the operator was driving. They can then determine whether they actually are impaired or not. As I've attached a lot of studies I encourage everyone to look at. They're very extensive from AAA and NHTCA on cannabis intoxication and blood concentration levels. And it's very clear that blood is not a good indicator. And I think, roadside sobriety is just really the best and the simplest way to go to not especially regress and accidentally target, especially legal industry workers and people like me who are just following the law, doing their job, shouldn't have to suffer.
Thanks for your thoughts on that.
And I
Thanks.
appreciate the question.
Thank you, Mr. Chair, through you.
Further questions or comments? If not, thanks for being with us.
Thank you.
Anne Marie Rosado.
Good morning.
Good morning, ma'am. Go ahead whenever you're ready. Ma'am, are you there?
I'm here. Can you all hear me?
Yep, go ahead.
Awesome. Good morning. My name is Anne Marie Rosado. I'm here to comment on Bill 7258. I am the founder of Higher Health LLC. We provide evaluations and certifications for those who would like to become a medical patient or renew their medical card. I am also a patient. I have been educating law enforcement as a consultant for the last 3 green labs with the GHSA. I am also a member of the state's driving impairment task force. Currently, there is no universal accepted device for cannabis intoxication. Reliability of these existing devices is questionable. Colorado, Illinois, Montana, Nevada, Ohio, and Washington have established a per se 5 nanogram whole blood level for intoxication. I am currently not in support of this. Blood tests can detect THC and its metabolites. However, they do not reliably indicate impairment. Due to the variable effects of THC on individuals, THC can also remain detectable long after the psychoactive effects have worn off. The period of detection for THC in a casual consumer is typically 12 hours, while a regular consumer or patient may be over a week. Those with more body fat have shown THC in their blood level longer than those with less body fat. Standard field sobriety tests are currently what is being used. These tests are typical for alcohol impairment as well. Without clear determination of intoxication, we cannot make a definitive law that may negatively impact a person's life. I encourage the state of Connecticut to invest more in law enforcement training, more specifically, advanced roadside impairment driving enforcement, ARIDE, and drug recognition officers, DREs. It is imperative to continue the Green Lab studies so law enforcement has cannabis education and hands-on experience. Testing of more screening devices as determination factors, not as determining factors, but as secondary devices is imperative. I also encourage patients and cannabis consumers to be responsible and respectful. I have also in my previous testimony suggested responsible vendor training. This would include cannabis impaired driving online education for all employees in the cannabis industry, and this would also be a suitable safety measure and option for medical patients. I firmly believe with research, training, and education, Connecticut will lead with safety and objectivity. I thank you all for your time and consideration today.
Thank you. Questions or comments from the committee? If not, thanks for being with us. Lisa Dalton will be next.
Good morning, esteemed members of the Judiciary Committee. My name is Lisa Dalton. I am the first Vice President of the Connecticut Town Clerks Association and the Town Clerk of Watertown. In an age where personal information is easily accessible online, privacy concerns have grown increasingly urgent. While public records are one of the numerous ways to obtain personal information, the CTCA wishes to express our concerns with Section 1 of HB 7255, requiring public agencies to redact personal information for those outlined in the bill. There are many complexities to what may seem like the simple process of merely clicking here and there to remove personal information such as an address from a record. The majority of clerks in the 169 towns of Connecticut have their land records published online. Many have online access for records going back decades and some even hundreds of years. The 2020 pandemic brought forth the importance of online access, and many municipalities have invested thousands of dollars to add more records. We wish to stress that the majority of our real estate industry is utilizing online portals to search title and retrieve documents and maps. HB 7255 not only affects land records, it also includes other municipal records such as video, social media, and audio meeting minutes. As written, this would require clerks to examine each and every document to determine where and if personal information is located. As holders of the records, clerks do not know what is referenced in each page of a document, nor currently have the software for this task. Individuals can have a multitude of documents ranging from deeds, mortgages, home equity lines, releases. In order to ensure that we have identified each and every record, the requester would need to supply the clerk with the exact volume and page of each record containing personal information. Clerks may find it necessary to discontinue online availability since current systems do not have the technology in place, and it is uncertain if our present vendors can support this and at what cost. Not only would clerks have to manually assess and examine each document previously recorded, but also future documents, as additional documents may be recorded after they're filing the initial request. CGS 1-217 currently exempts land records from redaction for certain protected classes. If this bill were to pass, would other protected classes also want to be included? And if so, would this be feasible? The bill also does not address the duration or expiration of these requests. Because of the complexities and unknowns of the bill as written, the CTCA strongly recommends the implementation of a task force to explore other states' redaction processes and the concerns outlined in our written testimony to achieve the goal of protecting the privacy of these individuals. I thank you for your time today and welcome any questions that you may have.
Thank you. Ms. Dalton, have you met with the judicial branch on this proposal that they've brought forward to us?
We did. We had an initial meeting. It was a great productive meeting. We did express some of our concerns. We were hoping to have a follow-up meeting so that we can further in-depth discuss some of them, but unfortunately we didn't have that opportunity.
Why not?
I'm not sure. I guess perhaps maybe time. We've had so many bills. Our legislative committee has been super busy at this time, but it's unfortunate. I wish we did have time so we can further examine, which is pretty much why we are pushing for a task force to really explore. We understand there are numerous other states that have redaction processes in place, and we would like to dive in and explore and really pull apart what they're doing to see how we can make it work for us.
So
We are a county, we're not a county-ship state as many states are. So our processes are a little different than some other states.
So am I to take that response to mean you prioritized other bills for your legislative commission instead of this one?
No. I'm sorry. Please don't take it that way. I honestly, I'm just not sure why we didn't have the opportunity to explore further with the judicial branch.
This committee meets with stakeholders on bills very early in the process, the judicial branch being probably first and foremost among those. And I know I met with the judicial branch, I think back in January on this proposal. And we require groups when they come before us to present a bill to tell us what organizations they've reached out to and what the response has been. And I know back in January, the judicial branch represented to us that they were trying to meet with your group to discuss this. And so I'm a little dismayed to hear that for the last 3 months, there really does not seem to be very much progress between the discussions between the Clerks Association and the judicial branch.
We did outline many of our concerns that are in our written testimony. So we did review those. I do know that there were 2 portions of the original bill that seemed to be updated, removing one being which was a 72-hour window for municipalities to redact, which that we expressed was a very short timeline to do so, and another being the liability to the municipalities. So we do see that there's a clause in the bill that would remove liability for anyone who did not remove at a reasonable effort to do so.
Right, so I take that to mean you that some of the feedback you provided to the branch, they took your comments and concerns into consideration in providing a updated draft to this committee I guess I'm trying to figure out sort of the remaining concerns, you know, why there hasn't been more progress. I mean, I hear what you're saying about a task force, but you know, if 3 months are going to go by and you're not going to meet with somebody, I don't know that a task force is going to do us very much good now, is it?
Well, I think the concern at this time is that we don't have the ability to identify the requester's records to redact their personal information, and towns may not be prepared for the implementation.
Right, so I'm going to leave this here for today because it sounds like what you need to do is get on the horn with the judicial branch probably this afternoon, because this committee's deadline to vote bills out is next week or 2 weeks. So, you know, we've got a little bit of time to make some progress. And I know from prior dealings, the judicial branch is very good at trying to accommodate requests where they can, but this bill will move next week, so I encourage you to get in touch with them. Further questions or comments? Go ahead, Representative Sapp.
Thank you, Mr. Chair. Thank you. Just so I think it would be helpful to understand the sort of the practicality of what we're talking about here. Looking at the bill, what documents do you think that this provision in Section 1 would concern? You know, looking at the land records, for instance, and the personal information that's identified, how do you think this would impact? We're talking about land records here, but also I assume birth certificates as well would potentially contain some of this information. What else in terms of just the practical implications of what we're talking about here?
Sure. So this Section 1 only affects online records. Birth records are not included in that. What our main concern are land records. Our land records, since 2020, many towns have invested a lot of money to go back in time to increase their online access, as many banking industries, attorneys, lending institutions, they're all using our online records. The difficulty is, I'm going to give you a prime example if you don't mind. I'm currently in the middle of, have applied for a grant and received and working on a grant project to go back further with our land records. This process that I'm doing is a simple snapshot of the books and the indices. So with that snapshot, there really isn't an ocular searchability. So it would make it extremely difficult for me. I would have to actually physically read the thousands of pages to redact at this time. Our current vendor, I had reached out to them. They don't have the ability to, at the current time, remove someone's personal information. They would have to look into that, add that if possible, and then there would be additional cost to my municipality to add that on, if they can add that on. So it's quite an undertaking.
Right. And is there currently any process or any technology that exists with respect to redaction? So if you were requested, and is there any other provision under law that requires you to redact?
So currently 1-217, the land records are exempt from that portion. So we don't have anything in place right now for redaction on land records.
Okay, thank you. Thank you, Mr. Chair.
Further questions or comments? Representative Osborne?
Thank you, Mr. Chair, and thank you for speaking on this issue today. And this is a technical question, and I'm kind of asking it of a lot of people who appear before us this year. And to the extent that you're seeking to take records that are not online and to put them online, isn't this exactly the type of analysis and task that AI is really good at performing, finding data, analyzing data, redacting in very short order?
Right. Our current vendors are very secure at this time, where on our searching terminals, we can't access the internet in any other way. It's solely that vendor's product. So to minimize the risk of any potential cyber attacking, remember, they are the base of our tax base. They're the beginning of our town, in that we store the record, the assessor then accesses the record, determines ownership value, which the tax collector then collects taxes. So we hold such a high regard to these records, and they're so tightly in security held that we don't have any other access to them. We would have to explore to see if our vendors can add this, as we refer to it, AI technology to do that. But currently, we're not aware that any of our vendors in Connecticut have that ability. And if so, we'll need time to add that feature on, and it will be a cost to the municipalities to add this on.
Thank you very much. Through you, Mr. Chair.
Have you reached out to the vendor?
I did. I reached out to my particular vendor, and they currently do not have this ability. Would have to investigate, and if they can add it on, it will be an extra cost.
When did you reach out to the vendor?
I reached out about a month and a half ago.
Did you inform the judicial branch that you reached out to the vendor and that was their response?
No, I have not. We did, as I said before, we did not have a follow-up meeting with them.
Okay. I mean, I think it would have been helpful to convey that information to them. So in the future, with respect to bills before this committee, we would appreciate you prioritizing those conversations. Thank you for being with us today. Next up will be Christina Capitan.
Good morning, Representative Stastrom, Senator Kissel, and Representative Osborne. My name is Christina Capitan. I'm a resident of Broadbrook and the co-founder of CT Cannon Warriors. I'm here today to speak in strong opposition to HB 7258. Let's be honest, this bill tries to bring the drug war back through the side door. It allows police to use the odor of cannabis to justify stops and searches, and we all know how that's played out. Decades of racial profiling, wrongful arrests, and civil rights violations, mostly against Black and Brown communities. Courts are moving away from this kind of vague and pretextual policing for a reason. In addition, the so-called per se THC limit might sound like science, but it's not. THC can stay in your system long after impairment is gone. Daily cannabis patients, especially medical users, can test over an arbitrary limit while being completely sober. I'm not only speaking here as an advocate, but also as someone who has personally experienced this injustice. In 2012, I was a passenger in a car that was pulled over on a highway for a minor traffic issue. Despite my full cooperation, a narcotics canine unit was brought in based on the alleged slight odor of cannabis. The officer claimed to see a grinder to break up cannabis in the center console, and from there began treating me as if I was trafficking in drugs. In reality, I was and I still am a person who uses cannabis responsibly to treat my severe PTSD. Nobody was using cannabis in the vehicle. But despite that, this escalated to a full vehicle search, which was triggered by the odor and visual assumptions, not by actual danger, not by criminal conduct. I was found with a small amount of cannabis, fully legal under current state law and decriminalized at that time. Still, this situation put my safety, my freedom, and my reputation at risk. This occurred just a week before Christmas and just days before I was able to obtain my medical cannabis card through a scheduled appointment. The police stole all of my medical cannabis, all of my rent money, all of my money that I had for Christmas presents for my son, and took me to jail and labeled me a criminal. I sat in that jail cell while my son eagerly awaited me to pick him up from his father's house and worried that something bad had happened to me. This kind of policing disproportionately impacts Black and Brown residents, and emboldening it through HB 7258 will only lead to more wrongful stops, invasive searches, and harmful arrests. So in closing, HB 7258, in my opinion, does not make our roads safer. It just makes it easier to punish cannabis consumers for using a legal substance, especially those who are already over-policed. If we're serious about public safety, let's talk about some real solutions, such as providing public education campaigns about safe and responsible cannabis use, access to designated consumption spaces to keep people from using cannabis in their vehicles, and training officers in science-backed impairment recognition, not guesswork based on arbitrary things like smell. We can also encourage rideshare programs or designated driver initiatives like we already do with alcohol. The drug war is supposed to be over. Let's not give it a reboot in 2025.
Thank you.
Please reject this bill. Thank you.
Thank you. Questions or comments from the committee? If not, thanks for being with us. David Moore will be next.
Good morning, Mr. Chairman, Ranking Member, honorable members of the committee. I am David Moore, and I have been practicing law for 36 years in the state of Connecticut. I was born and raised in the state. In fact, I was born and raised primarily in the Farmington Valley. That is one of the reasons why I am here to speak against raised House Bill 7255 relative to the changes of venue, particularly for the Farmington Valley towns. I also am here in support of raised Senate Bill 1501, but I'll leave those comments for the very end. The large law firms in the state and the well-to-do clientele are not going to be overly concerned about having to go from Hartford to Litchfield to address their legal concerns. Money is not going to be an issue for them. However, for the majority of the small to solo practice firms that are practicing in the state, it is, and there are 70% of the practicing lawyers are either from small firms or are practicing solo. This bill will have a dramatic impact on how they are able to practice law, particularly in the Farmington Valley. I should also note that I am currently the Secretary of the Connecticut Bar Association. I am not here as a legal representative of the Bar Association, nor am I speaking on the Bar Association's behalf. I am speaking specifically as a practicing attorney in Farmington Valley. If I have to end up going to Litchfield to deal with a variety of my cases instead of Hartford, it will add to my travel time, which will directly impact my clients. If I have a multitude of cases that are in different districts, moving from Hartford to Litchfield could dramatically impact my ability to actually attend hearings, to actually pay attention to what's going on in the various courts. And it's not going to actually fix the problem. One of the issues that I know is going on is the Hartford Family Court is jam-packed. I know that because I'm there on an almost weekly basis. The problem that we have is that changing the venue of 4 or 5 of the Farmington Valley towns from one JD to the next is not going to actually fix that problem. The problem lies with the fact that we are dealing with an increasing number of self-represented folks who are slowing the system down. If we end up having more people not being able to afford someone like me, you're going to end up with a higher percentage of self-represented folks who are doing their best to represent themselves, but won't be able to address the actual issues.
Questions or
I'm
comments?
out of time. I'm sorry.
Questions or comments from the committee? Representative Osborne.
Thank you, Mr. Chair, and thank you, Attorney Moore, for being here today. Now, at the outset of your testimony, you stated that, the large corporate firms and the clients that they represent won't be affected by this change of venue, but it will impact your business, not just your business, but more importantly, the clients that you serve. Can you tell us a little bit about who are the clients who hire these small and solo practitioners in the Farmington Valley, and how would the clients be impacted by the travel time? How much more time does it take to get from, say, the Terriffill section of Simsbury out to Torrington? Can you handle multiple cases in multiple jurisdictions right now, or will the distance between, the Hartford and New Britain and Litchfield courthouses, adversely impact your availability and your ability to handle multiple cases in a day and to disperse the travel time between multiple clients? Thank you, Mr. Chair.
Thank you, Representative Osborne. Yes, it would have a dramatic impact on my ability to service clients, but it's not just me. I have spoken to a number of members of the Simsbury Regional Bar who are also equally concerned about the fact that there isn't a direct route from Simsbury to Torrington. In fact, we would have to essentially do a dog leg, which adds about 20 to 30 minutes of time travel-wise. And for non-criminal stuff, most of the time, you're paying on an hourly basis. So someone who is charging somewhere between 300 to 450 an hour, which is what most of the attorneys in the Farmington Valley area are able to charge, that has a dramatic impact on what the client would be able to afford them to do. Furthermore, if I have a case in Hartford and I have a case in New Britain, I'm able to make both venues relatively quick without violating speeding laws. But if I was having to go to Litchfield instead of Hartford, that increases the travel time for me up to an hour. Okay, that's about $350 to a client who wouldn't necessarily be able to afford just paying for me to travel. So, and a majority of the folks who are in the Farmington Valley are between middle class and upper middle class. In other words, they're able to earn an average of between $80,000 to $150,000 a year. That kind of person is possibly going to be able to afford my services when I'm going to Hartford or when I'm going to New Britain. If I'm going to Litchfield, they're not. And so I either have to move my practice closer to Litchfield, which would directly impact both the towns of Simsbury and Avon, where I work and live respectively, but it would also impact a number of the firms that are practicing in the area. And I probably honestly will be the only person from the Farmington Valley who's practicing law to testify before this committee. Why? Because most solo firms and most small practice firms don't want to go up against the judiciary because there's always the possibility of a level of retribution, if you will. And in 36 years, I've seen that happen. So it's not a toss-up as far as what could happen. And I'm here because one of the ways that you could actually fix this is send Avon, Canton, and Simsbury to New Britain. There's much more of a direct line route to take than there is to Litchfield. New Britain also has better parking than Litchfield ever has, and you would be dealing with reducing some volume from Hartford, but you're not going to have a corresponding increase necessarily in Litchfield. So I respectfully request that this committee not allow for the change in venue as it has been proposed. And if I may very quickly, 36 years of practicing, I don't do a whole lot of probate anymore. And why is that? Because the fees that the practicing lawyers are allowed are so not in concert with what's going on as far as the fair market value is concerned for representation, that I will not touch conservatorships. I will not touch some of the things that the probate courts desperately need. So I would urge the passage of SB 1501. Thank you.
Thank you very much, Attorney Moore. Now, through you, Mr. Chair, one more. One of the things that we heard from earlier today was from the Litchfield County marshals who were here testifying on this same bill, and they had a concern about the service of TROs. And one of my concerns when they brought that issue up is something I hadn't thought about. Right now, there is, if I'm not correct, in fact, I know I'm correct about this because my son takes the bus from Simsbury into Hartford to go to school every day. So I know that there is public transportation, and And while the Farmington Valley is thought of as a place of, middle class to upper middle class people, I know as the Simsbury State Rep, we have 26% of our town is Alice. So I know that there are people who are employed or unemployed, asset limited, income constrained. And I know there are people who rely on that public transportation. To my knowledge, and maybe you can just educate me on this, I don't know of any public transportation that goes from, the Farmington Valley out to Torrington. And I'm concerned that we would have applicants who couldn't access services in the Litchfield Court precisely because of that. Do you share those concerns? Do you know of any public transportation that I'm not aware of that maybe our constituents, especially Terrifill's, 20 minutes from the Hartford Court. It's over an hour from Terrifill out to Litchfield. And those are the folks I'm most concerned about, the folks who can't afford services of an attorney, who may rely on public transportation and those sorts of things. Do you have any insights to that, or?
I do. There aren't any public transportation services available from the Farmington Valley to Torrington or to Litchfield County in general. So the only way that folks, if they didn't have their own transportation, would be able to make it to Torrington would be to either take an Uber, Lyft, or a cab. And if they're not hiring an attorney because they can't afford it, they certainly wouldn't be able to afford multiple round trips to Litchfield County.
I thank you for being here today, and I really thank you for speaking out on this issue. I know that people are hesitant to come publicly before the committee for a variety of reasons, whether it's founded or not. The very possibility of speaking out and the fear of having it adversely affect your clients, whether it's real or not. I've never found the judicial branch to act that way, but I understand the fear is there. And I thank you for speaking up on behalf of practitioners who were scared for their clients or were scared for their practices and didn't feel that they could come forward to speak about this today. I really thank you for sharing these insights with the committee and for stepping up to talk on this issue today. Thank you very much. Through you, Mr. Chair.
Further questions or comments? Further questions or comments? Let me just ask real quick, just a couple quick things, Attorney Moore. Just on the parking issue. So my practice is kind of statewide, and I've never had an issue with parking in I guess now Torrington. Litchfield, I will agree with you. There is a parking issue in Litchfield. Hence the reason there's this big, beautiful new courthouse with a nice parking lot in front of it in Torrington. So I just want to be clear, and maybe you were speaking about the old Litchfield courthouse, but I've never had an issue with parking in Torrington.
If we were to change the venue of 5 specific towns in the Farmington Valley, I think parking would become an issue fairly quick, because the volume of business that is generated from those towns would be an increase of almost exponential proportions relative to the need for parking. So it's not a current concern for parking, it's a future concern for parking were this proposed bill to actually become a statute.
Okay. And admittedly, I don't practice family law. My practice is civil. So on average, how many times a week are you actually physically in court now in today's post-pandemic Microsoft Teams world?
Mr. Chairman, it's interesting that you note that. I can assure you of the fact that prior to COVID, I was visiting about 4 or 5 different courts throughout the state weekly and sometimes daily. Since the pandemic, my visits to court have been more along the lines of 1 to 2 in person a week, and then about 1 or 2 hearings virtually per week. That's actually somewhat busy for a solo or small practitioner, small firm practitioner. I would say that part of the problem that we are dealing with, too, particularly in Hartford, is the fact that the Enfield Court got shut down during COVID. And the GA practice in Hartford has thus mushroomed to the extent that I sometimes am worried about the volume of people who are waiting in the gallery outside of the various courtrooms at the Hartford GA. Is shifting these 5 towns going to have a dramatic impact on that volume? Yes, it will. It will make things easier in Hartford to do things. But will it make it easier for Litchfield once Litchfield takes in all of this stuff? I would venture to say from my years of dealing with the courts, and by the way, I was a temporary assistant clerk for 3.5 years. So I know the inside workings of how the court system actually does things. The way that Litchfield would be impacted would be both positive and negative. The impact, however, for the folks in the Farmington Valley would be disproportionate to the benefit secured by Hartford and the potential benefit secured by Torrington by having this increased business, because the costs for the attorneys who are practicing in the Farmington Valley would go up without any end in sight as far as those rising costs. That would lead them to either leave their current practices in the Farmington Valley and get closer to Litchfield, or they would just not take those cases. That leaves a lot of folks underserved. And I would hope that we would be able to avoid that, not just because of the parking, not just because of we are dealing with an issue that does need to be resolved. I will grant you that. But I think taking the sledgehammer to swat a fly is not necessarily the best way of doing that. And I think that 7255 is indeed a sledgehammer.
Admittedly, my practice is more statewide, so I can't comment specifically. I mean, I have cases in almost every courthouse in the state, right? But I guess what I'm trying to figure out is, I recently had a case up in Litchfield, and we went up for a pretrial. And normally you show up for a pretrial in my home court in Bridgeport or in Hartford, and you walk in for pretrial and the judge looks at you and says, all right, have you guys settled this case? No? Okay, I'll see you again in a month, right? And you're in and out in 5 minutes. You're laughing because we all know it's true. I mean, a pretrial is generally a waste of time in most places. I showed up in Litchfield for a pretrial a couple months ago, expecting I was going to drive, nice, beautiful drive from Bridgeport up Route 8 to Torrington, and I was going to be in and out of there in 10 minutes. Well, the pretrial started at 10, and I was still there at 5 o'clock when they kicked us out. And at 4:45, the judge had picked another date and said, come back in 3 weeks and we will pick this back up. And we stayed there until 5 o'clock. And by 5 o'clock, we had a settlement on the record and the case was resolved in 2 days of being up the pretrial. And I tell that story because it shows to me that we have, not just do we have a surplus of cases and too much business in Hartford right now, there's too little business in Litchfield, right? I mean, and even when we were sitting there for 2 days, one of the other judges who used to serve on this committee, who was walking around, hey, how you doing? Da, 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 looking for things to do, right? And I think, I guess where I'm coming at is we don't, so much of it's virtual now. It's so few cases. I mean, you're only making, on most cases, maybe you're making 1 or 2, 3 trips to a courthouse during the entire lifespan of a case up until the time of trial. How do we deal with sort of not just the overage of cases in Hartford, but sort of the underutilization we have in Torrington? I think that's what the branch is trying to solve. And I'm curious as to, if this isn't the solution that's currently before us, how do we deal with both problems?
As I indicated before, Mr. Chairman, I think that one of the solutions would be to have 2, 3, maybe 4 of the towns that I've been speaking of report to New Britain as opposed to Litchfield. That would address the volume of business being done in Hartford, reducing it somewhat, but it would also not impact the clients as directly as a move to Torrington would. And I think that perhaps doing a further study to see where the most cases are being filed, why are they being filed there, and how can we do something to divert. Under the current statutory scheme, somebody in Simsbury has the ability to file either in Hartford or New Britain. We have that choice. The new language takes away that choice. So if you were to say, allow for, change the venue to Litchfield, Torrington for those 5 towns, but give them the opportunity to choose New Britain as an alternative venue site, I think that that would be a partial addressing of the situation. I think also that the reason why I was talking about the possibility of the creation of a study is that we might need to either reopen certain courthouses or open courthouses in another location. For instance, if we were to reopen Enfield, the GA volume in Hartford would go down by almost a third. Almost a third. And we're packed like sardines in there Tuesday through Thursday. I do civil practice as well as family and criminal. Most of the civil practice would not be directly impacted because of the virtual hearings. I will grant you that. Nonetheless, you still have the issue of eventually having to show up to court to finalize a stipulation, finalize an agreement that ends up being a judgment, whether it's in the civil venue or in the family venue. You don't have virtual hearings in criminal cases. Only when you have witnesses or possibly a defendant who's from out of state do you have a virtual hearing in the criminal venue. So the fact that the technology has allowed for more hearings, actual trials being done virtually, is great. But it doesn't address the volume of work still to be done necessarily. And it only happens in certain discrete areas of the law.
Okay. All right, I hear you. I guess if we move more stuff to New Britain, then we got to move New Britain to Litchfield, though, is sort of the corresponding move. But anyway, all right.
You could move Bristol to Litchfield. That would have an impact. Bristol is not going to be directly impacted as much as the Farmington Valley would be relative to the change of venue.
All right. Last time I was in the Litchfield Torrington Courthouse, I actually saw the good representative from Bristol there. It wasn't the same case, but we were both there at the same time. We had a lovely day in Torrington that day together. So, all right, Representative Blumenthal.
Thank you, Mr. Chair, and I apologize for asking a question after the chair, but one of your colloquies spurred a question in my mind, and I appreciate you being here and offering your testimony. Would there be any potential amelioration or alternative solution from your perspective through making some of these towns be part of a swing for at least some categories of cases?
We've had practice in doing that. For instance, if you are in the Durham Middlefield area, you would have the choice of either going to Meriden or to Middletown. If you are in Simsbury, you have the choice now of being able to go to Hartford or New Britain. I think that that is a practical approach and a partial solution. It's not the full solution, but it at least addresses certain aspects that would make it more tolerable and frankly, more affordable.
Okay. I appreciate your testimony and you being here for us today. Thank you very much. Thank you, Mr. Chair.
Further questions or comments? If not, thanks for being with us.
Thank you very much.
Melissa Mayashek? Sorry about that.
Oh, hold on, let's move on over here. Okay. Hi, everybody. Thank you for allowing me to come speak today. My name is Melissa Majak. I'm the president of The Movement. It's a harm reduction and recovery nonprofit here in Connecticut. I'm here to oppose HB 7258, an act concerning driving while under the influence of or consuming cannabis. Earlier, there was testimony that seemed like it was just for people while they're driving smoking, but that doesn't seem like that's what most people think that this is about. It's more of a way to target people who are using cannabis for a variety of reasons. There's no secret that people have been unfairly targeted by police officers, and this sort of opens the door to stepping backwards into the war on drugs. Smells can be misinterpreted, things can be confused for each other, and also cannabis odor sticks around long after the substances, being consumed. There's places where people smoke on a regular basis and you can smell it. Doesn't mean it's somebody who would be under the influence at that time. Maybe there's somebody, who's a grower or a caregiver. Maybe there's somebody like myself who is really as whole of a person as they are, not in spite of being consuming cannabis, but because I'm able to consume cannabis. I have consumed in my parked car to avoid smoking in the house with my under 18 child. We have a 1-bedroom apartment, and so I'm not going to smoke inside. So I have smoked in my parked car in my driveway. That doesn't mean that I drive while I'm under the influence. People who have used cannabis to combat anxiety and pain, and medicinal users, oftentimes their levels are astronomical in their blood levels or urine, but they're simply not under the influence and could pass a driving test. So I'm in recovery myself. I was hit by a car at 55 miles an hour while I was crossing a street. During my recovery, I've been prescribed medical marijuana and had to increase the amount that I was prescribed by the state of Connecticut, which means that I myself am prescribed 1.5 ounces a week, which means I smoke about a quarter of weed a day. And I have started a nonprofit, graduated college, got my child custody back. I have started a recovery organization. I founded a recovery fellowship. And not once, after driving about 1,000 miles a week for the last 5 years for work, have I ever even gotten close to an accident. This is being looked at as alcohol, and it's not alcohol, it's medicine. And there are people who prescribed painkillers, people who are prescribed benzodiazepines and other sedatives that somebody sipping a sip of water and taking a pill while they're driving doesn't get looked at as, oh, I'm taking a sedative. And it's looked at on a prescription bottle to avoid driving until the intoxicating effects are known. And that should be across the board for cannabis as well. I'm not promoting using while driving or actively consuming behind the wheel. However, there is not a scientific way to identify the level of intoxication that somebody is experiencing. And it's just a way to provide collateral. I myself will be
Thank you.
collateral damage for others.
Thank
And
you.
I'm open to
Questions
questions.
or comments from the committee? Seeing none, thanks for sticking with us.
Sir, I'm sorry, Mr. Chair. Mr. Chair.
Yes, hold on, ma'am. Representative O'Day, who's online.
Sorry, Mr. Chair. Just real quick, did I understand your testimony that you think it's okay to smoke marijuana and then drive?
I absolutely think that people who take prescription medication should be allowed to perform daily tasks as their medication is intended to give them the ability to do. I am not saying that somebody should be high and, totally unable to drive, but there are people who take prescription pain medication, go to the methadone clinic every day, and they are allowed to drive. So it should be no different for cannabis.
So your answer is yes. So you think people should be able to
Absolutely.
smoke and
Yes,
drive?
people should be allowed to use medicine and be able to perform daily tasks. Yes.
And you go outside and smoke in your car to avoid having the smell in your house with your minor child?
I have smoked in a parked car, yes. I don't frequently do it. Now I have a set porch. We've moved into a bigger apartment, but when I first got my card and I could not afford a bigger apartment, no. Where are people supposed to smoke? You're not allowed to smoke in your apartment. Your landlord's going to kick you out. You're not supposed to smoke outside. If you smoke in a parked car, now you're being looked at because you're driving perfectly capable and there's no, effect on your driving at all.
Okay, I appreciate it. Thank you, Mr. Chair. Thank you for your testimony, ma'am.
Further questions or comments? Seeing none, thanks for being with us. Joseph Asachulo?
Yes, good morning, members of the Judicial Committee. My name is Joseph Achitulo, and I am the co-founder of the CT Can Warriors. I am here to oppose Bill number 7258. I believe that consuming alcohol or cannabis while operating a vehicle is unsafe for both the passenger and driver and should never be allowed. However, using the odor of cannabis as an indicator for a search or blood test is totally unjust, especially in Connecticut, where cannabis is now legal. The natural scent of cannabis can be present in cars of legal cannabis users and workers of the industry. The skunky smell always lingers on you, especially if you have dry flower or hash in your possession. Its mere presence should not be grounds for suspicion or a search of the vehicle, seeing that cannabis, again, is legal in Connecticut. Therefore, the smell or odor should never be used as justification for infringing on individual rights or initiating searches. Thank you for your time.
Thank you, sir. Questions or comments from the committee? Seeing none, thanks for being with us. Duncan Markovich? Markovich.
Can you hear me? Can you hear me?
Yes, sir. Go ahead.
Okay. Good afternoon, Chair Senator Winfield and Representative Sastrom, ranking and member of the Judiciary Committee. My name is Duncan Markovich, owner and founder of Better Ways, a cannabis education center in Brantford. As written, I oppose HB 7258. However, I would like to offer some suggestions that I hope this committee might take into consideration to make this bill's language a little more comprehensive. My points of concern are the allowance of search and seizures based on odor, how officers will be able to distinguish the smell of burnt or unburnt cannabis in a vehicle or on a person, the design and impact of drug recognition experts, and the considerations made when calculating toxicity levels over impairment as regards to seasoned medical cannabis patients, especially with blood tests. In unison with this committee, I am equally in support of the true intention of this bill, which is all things safety. I do not feel that any substances that intoxicate the operator of a moving vehicle to be consumed, whether it be alcohol, cannabis, or prescription drugs. Last year's unfortunate track record of 329 alcohol-related motor vehicle deaths illustrates our state's continued need to address the scourge alcohol presents on our health, our roadways, and our society. I appreciate that there are efforts to repeal the state's open container laws so we have some equally balanced common sense laws with regards to a safe environment inside a motor vehicle. Education will always be the Occam's razor for many things, especially in these instances of public safety and enforcement. As identified earlier in this hearing, the infrastructure of Connecticut's drug recognition experts around marijuana needs to be bolstered, as well as the science and technology needs to catch up as well. Please always keep the ideal of education over enforcement when crafting these common sense cannabis laws, and continue to utilize those within our industry, community, and culture to galvanize the state's existing emerging industry and existing culture in our responsible society. So there's this concern about toxicity versus levels of impairment. This is a dynamic plant-based medicine. I use cannabis daily for pain management and nerve damage. And as I shared with Representative Howard the other week, I feel that cannabis is adaptogenic and therefore toxicity versus cognitive and motor impairment varies greatly since cannabis is always an individualized experience. He noted the odor on my person, even though I had consumed hours before, not affecting my my cognition in the moment. When I'm having an intense pain day and I medicate with certain protocols, I do not get high, and thankfully I am noticeably in less pain. If I'm having a low pain day and I medicate in the same manner, the high is more noticeable but equally not unmanageable. I share this as a point of clarity that this personal experience with cannabis and pain management is not the same as with pain management and opiates with regard to impairment impact.
So that was the bell. Thank you. Questions or comments from the committee? If not, thanks for being with us. Olivia Rinkus.
Good morning, and thank you to the Judiciary Committee for the opportunity to testify. My name is Olivia Rinkus. I'm from the town of North Stonington, Connecticut, and I'm also an undergraduate at the University of Connecticut studying political and cognitive sciences. I'm testifying today in opposition to HB 7458, an act concerning driving under the influence of or while consuming cannabis. This legislation is moving backwards. While cannabis has been legalized, this allows the smell of cannabis to be a basis for a police interaction, which essentially recriminalizes it. This legislation and allowing the sense of smell, which is extremely, this legislation allows the sense of smell as a basis, which is extremely subjective and increases bias against cannabis. It is still fully legal for officers to pull over individuals for exhibiting signs of impaired driving. As others have also testified, the use of a blood test as a means of determining current impairment level is also extremely subjective and not accurate. Further research is needed to understand exactly how cannabis impairment works and more efficient test methods. And further recriminalization will prevent that. Please say no to this legislation that stigmatizes and criminalizes cannabis and focus it instead on repairing the effects of the racist and ineffective war on drugs. I would also like to comment on a few other bills. First, HB 7257, 7261, and SB 1549, all of which are related to studies of criminal law and procedure. I believe the wording of these legislations should be expanded so that taxpayers understand exactly what the studies are looking for and what the goals are. I also believe these studies should be expanded to include public defender representatives as a crucial component of the criminal justice system, as well as individuals with lived experience of incarceration with the justice system. And finally, I would like to testify in support of Section 8 of HB 7259, an act concerning revisions to various statutes concerning criminal justice, which increases pretrial diversions to individuals with autism and other intellectual disabilities. I support the use of non-carceral options for any individual, but particularly for individuals with mental health needs. I hope that legislators will work to ensure that the services provided are not based in policing, surveillance, and punishment, but rather utilize services focused on consent and autonomy. I also hope that future legislation will expand to include individuals also with substance abuse issues. Thank you very much for the opportunity to testify.
Thank you. Questions or comments? Seeing none, thanks for being with us. Ruben Said. How about Peter Smith?
Good afternoon. Chairman Stastrom, ranking members Kissel and Fishbein, and distinguished members of the committee. My name is Peter Smith. I'm the city clerk of the city of Milford. I'm here today to share my experience as the city clerk of Milford and express concerns regarding Section 1 of 7255. Last June, I made a career change, leaving behind the familiar routine of walking these halls and bothering some of you on particular issues. And I accepted the opportunity to serve out the unexpired term of the city clerk in Milford, returning to public service in a town that I once served as state representative. Since then, I've had the privilege to join the CTCA Legislative and Elections Committee, where I've been asked to convey significant concerns the town clerks have regarding this bill. I have submitted written testimony, but I'm going to talk a little bit about the conversation and the back and forth that was going on between Chairman Stastrom and Lisa Dalton. I think that as Lisa expressed, my understanding, and I'm stating this secondhand because I wasn't in the meeting, but there was one meeting between the association and the judicial department. At that meeting, several dozen concerns were raised. And the next time there was communication back from judicial was when the bill was released. And so what Lisa was expressing is that of that large list of concerns, 2 items were addressed. And I do think I will say from my experience in becoming the town clerk in Milford, it's something that you sort of conceptually understand, but when you get into the office, you realize the depth and breadth of all of the issues that you're dealing with. For instance, one of the things that we've undertaken just recently, because the attorneys in the Milford Bar Association and the title searchers had requested that we add more of our land records online. So Milford's land records are digitized from current day to 1967. We're now moving from 1967 to 1960. And this is through our vendor, so that anyone would be able to access from their office all of the normal things that you would come in and have to search through the vault on. And so the concern is that we use one vendor who happens to provide services to about 58 other towns. There's another vendor who provides services to 48 other towns. Each of these vendors have their own pluses and minuses. And I will say that technology is making a difference. And I believe it was Representative Osborne had talked about AI having an impact. AI is having an impact. I don't think it's there yet, but in the future, I do think there will be some technology changes that allow us to deal with some of these redaction issues. But the concerns that, I think from a timeline perspective, and Mr. Chairman, I completely agree with you that you have an expectation that a lot of this stuff is worked out. But and what I've heard from the association and the president and others is that they're more than willing to have those discussions, but there just hasn't been time.
So I obviously we're both hearing this secondhand hearsay, so I'm not gonna
agree.
But that's not the story I've heard. I think what I've heard is that there was this initial meeting that the Town Clerks Association was supposed to follow up with their vendors to determine whether this is something that can be done or not. And the first time judicial heard that outreach had been made to the vendors and that the vendors said they don't currently have the capability to do it is when I asked that question half an hour ago. So, look, we've got a JF deadline coming up, and then we've got some time after that. I'm not one to sit here and want to punt this to a task force in the off session. I think there's plenty of time between now and early June. So I would suggest the Town Clerks Association prioritize getting in a room with the judicial branch and report back to us on how that meeting goes.
And I think that is what the plan is. I do want to point out, and this is as you would understand, all of these things have impacts. I mean, and it's not just land records we're talking about. It would be information that was presented in an agenda for the Board of Aldermen. And if we had a person who happened to be in that protected class going on a municipal board, we may not know that that's a protected person. That name and address may be exposed. And I think what at least the interaction that I've had with the municipal clerks is they take that job very seriously. And so what we're looking to do is try and find a solution that actually works, not just saying we'll do it and things slip through the cracks, but actually operationalize
I
it.
get it. And I don't think any of us are trying to ram something through that isn't going to work. And I certainly don't think the judicial branch is looking for that. I think we understand the policy implications here. My concern, like I said, is, you have anybody know how this process works?
Yep.
And, the judicial branch met with us in early January, met with leadership of this committee in early January on this proposal. I knew from back then that they were making outreach to the Town Clerks Association. I find it sort of dismaying that an outreach was made to a vendor to answer a question judicial had a month and a half ago, and that information was not conveyed back to judicial, if that's what happened. So there may be three sides to every story, but like I said, let's leave it at this for today, and I'll wait to hear back from the branch and from you guys as we get closer to our draft deadline and then thereafter.
And
All
we will do that.
Thank you, sir. Further questions or comments? Representative Fishbein?
Thank you, Mr. Chairman. At a level, it appears we're speaking in code here. I just want to, I think I know, well, I think I know what we're talking about, but within the context of this, where somebody's residential address is sealed pursuant to statute, so like a judge. And I've always questioned this because, the judicial branch, they used to put out a pamphlet, a book with the judges and what town they lived in. And I could go to the land records and I could find out, that a judge resided at a particular place. It's not that difficult to find a police officer actually through the land records also. A little bit more difficult. I would suggest as these discussions come about that perhaps it's an opt-in thing where somebody recognizes that they are a protected individual and they notify their town as such, because I do recognize the problem. And I do recognize that it is somewhat heavy lift for a vendor dealing with land records, but that's perhaps the way to deal with it. So just wanted that noted. So thank you, Mr. Chairman.
Thank you.
Representative Godfrey?
Thank you, Mr. Chairman. Disclosure right off the bat, Mr. Smith and I were first elected to the Connecticut General Assembly at the same time. We've known each other for a very long time, and I certainly count him as a friend. And I have concerns about this this entire issue. Now, I've been a champion on the Freedom of Information Act side of things from before I was first elected to the Connecticut General Assembly, and protecting judges was the first explicit exemption to the FOI statutes. Now, let me put that in a little context. FOI is, yes, about citizens and residents and plain old people and businesses having access to the goings-on of government. We are their government. They should know what we're doing. From the very beginning, however, the flip side of that coin, which is privacy, has also been protected by the Freedom of Information Commission. I worked back in the day with Mitch Perlman to make sure that that was understood and included in state law. And so we got this unnecessary exemption for judges because personal information in any employee's personnel record is not accessible under the Freedom of Information Act. It never has been. And since then, we've seen group after group after group wanting a similar explicit exemption that frankly no one has actually needed because it was covered since Ella Grasso first provided for a Freedom of Information Act and Commission. And indeed, Government Administration Elections Committee has been considering, and I think voted out, a bill to make it completely clarify that you can't go to any state, municipal, government employee and get their personnel records, the personal part of their personal records is not something subject to that, including judges. You can't get this now. We had a big kerfluffle a few years back with does this include voter registration information? Now, my colleagues and I here on the Judiciary Committee, of course, live or die by the voter list. Those are the people we go to every couple of years to solicit their vote for us as we run for office. And there was such confusion to the point where the town and city clerks just said, okay, we're not going to release the voter files. Well, we had to rush in and fix that. And one of the ways we fixed it is if you're in a protected class, you could ask to have your name and address redacted from the voter files. It wasn't something automatic because, quite frankly, and P, if you can confirm this, you have no way of knowing who members of this protected class are, especially since we're considering not only a judge, we know who they are, but their family, including their kids who could have a different name, could live in a different place. That this would cover that. I would be much happier. I oppose this provision, but I'd be much happier if there was a trigger that said you had to ask to be this redacted. And then the second part of my question, when you're looking at land records, I live on Stillman Avenue here in Danbury. I'm at number 13. My information on my home ownership is on record at in the town clerk's office, both in the vault in person and online. So are the people up and down the street. But if I'm doing a search of who owns the property on my street, and all of a sudden I come up with, gee, the people number, there's no record at number 10, under this provision, I will know that it's a judge. Then 3, on top of it all, I can get information on any person on the internet, anytime, anywhere, including their social security numbers. Law firms can have actually subscribed to information sources that can get you that kind of information. So I think this is overkill, and I'd like to hear your take on these 3 issues that I just raised. Thank you.
You've actually articulated some of the challenges that I think my understanding was raised in the informal discussions that they had originally with the judicial agency. I think that the challenge that I see, and you enumerated them well, is, number one is we need to make sure we have a list. Again, I'm going to go back to the point of, I think AI in the future will give us a greater opportunity, but you end up with a multitude of different places that this information can be stored. And I think that's really the challenge. And to sort of go back to what Chairman Stastrom was asking, is it's incumbent on sitting down and having a deeper discussion, attempting to find out those solutions. I don't think any proposal that's put forward is going to solve everything, but I do agree. I think we all agree that we should do the best we can to make it difficult to find that information. And we're committed to do that, but it's not going to be something. And the other point I want to add is that we're also cognizant of the fact that we're talking about the judiciary, but we also know there are other protected classes that will soon follow. So I think it's important for us to look at this holistically, not just the judicial branch, but also what happens on the state side of the equation and the local municipal side as well.
Thank you. Further questions, comments from the committee?
I'm not quite finished, Mr. Chairman. I agree with Mr. Smith very wholeheartedly. And I am going to run this proposal by the Freedom of Information Commission people because it does affect, because we're on parallel tracks. And you talk about AI, which I'm a member of the AI caucus. Privacy, to my chagrin, has gone the way of the dodo. You can get any information on any person at any time just by a few clicks online. Sometimes you have to pay. Sometimes you get it for free using a search engine. And the problem I have is the inability, as you mentioned, of someone responsible for these records to know. Under the current proposal, you don't know who is the protected class. Are you going to guess? Are you going to just say, okay, we'll take the entire record, the entire ownership record offline? That still means you can come in person and get the same information. And it just drives me crazy. There's got to be a better line. And I'm willing, if it's necessary, to facilitate a meeting that includes the clerks, the judiciary, and even the Freedom of Information executive director who I will be consulting before the day is over, to put this together. I'm very concerned that this is overreaching, and it actually could make it easier to find this information on judges and judicial employees. So, thank you. Thank you very much.
Senator, further questions or comments? If not, thanks for being with us, Pete. And that will conclude our public hearing for today. Thank you all for, you weren't signed up. You weren't signed up to testify. We can't under the under the Freedom of Information rules. So that will conclude our public hearing for today. And we will not be meeting Wednesday, just so folks can mark their calendar. We will not meet Wednesday. Members should hold their calendars for Friday for a potential meeting Friday, likely caucuses followed by meetings on Friday. And then next week is our JF week. We will be meeting Monday, Tuesday, not Wednesday because that's session day, Thursday, and then Friday. So no meeting this Wednesday, no meeting the following Wednesday, but every other day folks should plan to be together. See you, everybody.
Want to speak to me in here in the hallway? Oh, we can do in the hallway. Perfect. I'm gonna go get set up out there. All right. Yeah, I don't know what it is because I have a couple screenshots anyways, but it's like, when I've tried to register, the last few times it keeps rejecting me or something.
Yeah. Yeah, probably. Don't worry, I was
On their non-day.